Hello friends, last class we have studied something on basics of law, then we came across contract, and then we have also discussed something on essentials of contract, types of contracts, and also we have come across normally the contracts in daily life. Now very important thing is now again we will discuss something on intellectual property rights. So intellectual property rights, because so today I'll tell you one thing, when you have a property of your own, then ultimately there is no problem for anyone. But in case if the property is earned by you and which is copied easily by others, then there is a problem, because in today's world we can find that normally we can connect this to Indian crab story. I think you all heard about Indian crab story. Indian crab story clearly says that, see, the first of all normally again all these crabs in internationally are kept in a particular container. All the crabs will be as it is, whereas normally Indian crabs will find it very difficult to climb up, because the moment one crab climbs a step, ultimately second crab is there who pull down the legs of the first crab. So ultimately what happens is normally there is no container required for this. So in the case of normally the other crabs, normally we find that normally the containers may be required very much. So in such case, what is required to be done here is normally when one person tries to pull the legs of others, normally the other person should be very much alert normally as to not to become victim of anyone. So in such case, normally so what is important is your product designed or your services designed or your innovations or inventions made should be protected. So in such case, to receive protection for normally your asset, anything or any valuable or any property, they require something called as knowledge of intellectual property rights. Legally it is valid, and normally court has also approved the same. So what this intellectual property is, now again see the, when anything is made on his own, it becomes his own intellectual property, whether it is a design, trademark, copyright, patent, or registration, whatever is there. So that all this becomes his own intellectual property there. You can have the music of your own, you can have normally the design of your own, you can have normally the asset of your own, book of your own, see, the lyrics of your own, dialogues of your own, whatever is there. So all these things are the part of your own inventions. So the more the inventions you make, more you get noticed with the eyes of others. When you get more noticed in the eyes of others, there are chances that people want to come to your level or perhaps exceed your level. So in such case, what they do is they adopt some dubious means to succeed. So in such case, what you ought to do is you should take care to see that others don't copy from you. So basically what is happening is, so many of the Indian authors we can find that normally almost the textbooks are copied, and how they protect themselves is they will directly write according to so and so, this is what is the definition. Second definition, according to so and so, this is what is the definition. So in such case, what happens there is normally they protect themselves that it is not their own idea, it is somebody else's idea, but they are just putting forward those ideas in the books. This is there. So in such case, normally we find that the intellectual property right is not violated. That's why they are escaping from these kind of things. But in case if there is normally word to word copy, ultimately they can be prosecuted. Under law, they can also be convicted. That is possible. So now let us see that what this intellectual property is now again. So the intellectual property, as far as our understanding is concerned, it is your own property, whichever is now made by you yourself. Now, intellectual property right means in your property you have a right. Say for example, if you own a house, now again, when you are owner of that particular house, you have got 100% right in that particular house. But neighbor's house, you don't have a right. So in such case, what we have to understand is when we have a right on it, we can do anything. We can let it out for rent, or we can only say construct a shop in the front and then again occupy the back side. Front we will get the rent out of that. So which means that we have got the right on that. We have got the right to earn income from that. So when income is more, ultimately, obviously the people normally who are others will have an eye on the same. So in such case, there are possibilities that normally they can just get to your level itself by again copying your own idea and becoming your direct rivals or becoming your direct competitors. That is there. So this is something about intellectual property right. Intellectual property right can be in the following forms. First thing is now again it can also be a patent right. Patent right. Suppose if in the case of food industry, you might have noted that now again when you prepare new delicacies or new recipes, they take a patent right saying that the following ingredient is prepared by me and I get the patent there. Once the patent right is registered and you have it in your hand, others cannot copy directly the same taste or same delicacy in the food industry. Suppose in case if they want to copy the same, ultimately what they have to do is they have to take your permission, and today in this practical world, no one will give the permission free of cost. Suppose if they want it, ultimately what they have to do is, again, they have to take your permission, for which again you can charge them, you can claim any amount for them, or you can demand the amount. So ultimately they have to pay the demanded amount and then take your permission there in writing. That is possible. In case if they fail to take the permission, you can put this matter in the court and see them in the court. That is possible. So this is possible in the case of patent. The patent can also be found now in the case of automobile industries. See, today what's happening is, see, Maruti Suzuki Motors, we find that normally diesel engines normally again, it's manufactured with DDIS technology, direct diesel injection systems. So ultimately what happens there is, Maruti do not have the right in technology. Technology is normally imported from Japan. So the Japanese firm, whichever manufactures this technology or whichever has produced this technology, has got a patent right on this. So in case if Maruti has to come out with a diesel engine, they have to pay a royalty to them. The royalty is charged by the actual owner there, whoever has invented this technology. So after paying that patent as a royalty, then it is possible to use the same, that too for a specific period of time. Now what is the time in which the patent is valid? Patent normally is valid up to the period of 15 years from the date of issue. Then it has to be renewed. So for renewal there are some conditions, that is not discuss more about that, but it has to be renewed. Please understand, it has to be renewed for a particular period of time. Then again the same thing repeats. This is something on the patents. Next is copyright. So many a times normally you might have seen that in the case of music industries. So suppose if there is a song which has been sung by the Dalar Mehndi, say Punjabi hits. So ultimately what he does is, he refrain others from copying the same, even whether it's a lyric or whether it's some words or whether it's any part of the song. So ultimately he takes the copyright on that and make sure that the letter C is written there, which means that it is copyrighted. When it is copyrighted, there is a legal permission given to him to own that particular song. So in case if anybody wants to dub that music or use that music for some other things, normally has to take the permission from the Dalar Mehndi, for which normally that Dalar Mehndi is authorized. Ultimately what Dalar Mehndi says is, you pay so much as my compensation, then I will give the permission. If not, he will not give the permission at all. So this is possible in the case of copyrights. You can take copyright for your books, you can take copyright for your normally the research works, you can also take copyright for your articles written, you can also take copyright for normally the music or any dialogues written or any kind of innovations you make. So that is also possible. So in such case copyright has got more validity in the world today. Next one is industrial design. Suppose if there is a particular design made by you, that design should not be copied by anyone, means something, you have to take the respective the legal patent for the design. For example, now design made by Audi cars or any luxury cars, that cannot be copied by normal the basic cars, because now there is a patent for that. So in such case, in case if they copy that, a suit can be filed against them. And even this is also applicable in the case of software and other technologies. Say for example, now again there was a suit filed against the Samsung from the Apple company, saying that their respective design was stolen by them, display was stolen by them. So in such case normally Apple has won the case, because whatever the work which has been done by the Apple is original and they own that. So suppose if Samsung has to manipulate their work, now again they have to get their legal permission in writing, and legal permission in writing cannot be given free of cost. So the company will charge for the same. After paying the prescribed charges, then they will get the copyright done. So design, make, and as well as the model, whatever is manufactured, everything is subject to the patent. Next one is the plant variety. So the plant variety indicates suppose if you have got a particular plant having a hybrid technology, you have got a hybrid plant. In that case, normally what you do is the manufacturing capacity will be more there. Output will certainly be more. Why? Because first thing is it is more of technology based, less of labor based, less labor intensive. So in such case, what happens there, now again we find that there is no errors, no supervision required, no maintenance required, everything will be done by itself. Machine has to be programmed. So in such plants, normally we find that there are possibilities of manipulation. So in order to prevent others from manipulation, it is better to take the patent on the same. So this you have to understand here. Next is trademark. A particular mark is given normally for a particular product, which indicates that normally it is original. For example, now you can see the monograms of the vehicles, any monogram. So for example, in front of Tata vehicle there is a T. In front of Ford, normally their Ford logo is there, which also its trademark. So that indicates the identification of the product. Please understand, it indicates the identification of the product there. So the product is identified by a particular trademark. Based on the trademark, normally again they get the recognition in the market. So in order to again take the trademark, it is not at all possible. Why? Because Once the trademark is owned, it belongs to that particular company itself. Here, no royalty, nothing is possible. Once it is owned by the company, it belongs to that company. Nobody can take it away from the company. Understand this. Okay, so this is one part which we have to design and we have to again understand when we discuss about intellectual property rights. More about this we will discuss in next video. Thank you very much.